Great. Good morning, everyone, and welcome to our IP info session for the Learning Labs program. My name is Dubravka Jurišić. I'm the project manager of Creative Flip project working at the Goethe-Institut in Brussels. And I'm here together with my colleagues Charlotte from the Goethe-Institut, Elena from the Lotto Zero Creative Hub in Prato, Italy, who is our sustainable fashion expert on the project, and my colleagues Onur and Cyrille from the Intellectual Property Institute from Luxembourg, who will introduce themselves and actually talk a lot today. So the goal of this session is to provide information on intellectual property rights with a special focus on the fashion industry for the cultural creative sector. It is targeted at people who are interested in potentially applying for the Learning Labs program. But everyone is, of course, welcome to join in and listen because it's really universal knowledge. And one of the goals of our project is to help spread the word and raise awareness about the value of intellectual property rights among the cultural creative sectors. So today I will just, together with my colleague Charlotte, give you a brief introduction about the project, but then we will dive deep into the IP topic. And in case you want to know more about the Learning Labs program as such, we have another Q&A coming on another date. So that would be the best opportunity to ask other questions about the program. Onur, maybe you can go to the next slide. Great. So the main objective of the Creative Flip project is to support cultural creative sectors and industries, to address the main challenges they are facing in their work, to increase their long-term resilience, to improve their collaboration amongst different sectors of the CCSI, but also with actors outside of the sector, and also to prepare them to tackle future challenges and transformation processes, which we know are now definitely unfolding across the globe. Next slide. So this is a third phase of the project, and it's running until 2026. So we've just recently started with the latest project phase. And the main themes have kind of continuously grown since the start of this project, and are focused on finance for cultural creative sector, learning, innovation, working conditions of artists and cultural professionals, transformation in terms of green, digital, and social transformation, and of course, sustainability and intellectual property rights. Our project is funded by Creative Europe, and we are a consortium of 5 partners, the Goethe-Institut and IPIL, who are here today, but also our partners, European Creative Hubs Network, Idea Consult as well. And we have associate partners who are Culture Action Europe and European Network of Cultural Centers. We do many different things in the course of the project. Learning Labs is one of the most, let's say, hands-on activities, and also then a little bit like one of our favorite activities to do, because we really get in direct touch with creatives and culture creative professionals. But one of the definitely key and, let's say, most famous flagship initiatives of the project is the Creatives Unite platform. I don't know if you've already heard about it, but if not, we would definitely invite you to check it out. In addition to providing really daily information on the hottest topics in the culture creative sector and all the news, you also have very valuable tools there on, it's called So You Need Money, so for financial and funding opportunities. Then this is how we work on the legal framework in different EU member states when it comes to working conditions of artists. And finally, of course, on my intellectual property on IP, but I would leave this topic more to my colleagues Onur and Cyrille. And I would now give the word to my colleague Charlotte, who will tell you a little bit about the Learning Labs program.
So yes, as Dubravka already mentioned, this info session is part of the Learning Labs program of Creative Flip. But what does it mean? Well, Learning Labs are innovative cross-sectoral cooperation project between culture and creative organizations or small medium enterprises of the sector and a local school. So their objectives are to connect, on the one side, cultural and creative professionals with their local community to create long-term connections, and on the other side, to increase the students' creative transversal skills and at the same time to raise awareness for sustainability issues and the intellectual property rights through hands-on workshops. So it's a very practical program. And right now we're having the open call for the third round of learning labs, but it's the first time that we have a very specific focus. The last time it was very wide. This year we're looking for creative facilitators who will do workshops on sustainable textiles and fashion during the second half of this school year. So from January 2025 until July 2025. So very soon, the open call is open until the 24th of October. So we really encourage you to apply and to become one of the 10 creative facilitators we're looking for right now. What we give the creative facilitators is a grant of 5,000 euros to implement their learning labs in a local school. And as part of the learning labs, we also invite the creative facilitators to a peer learning exchange. Maybe we can go on the next slide, Onur. Exactly. And this peer learning exchange will take place at the halls of our experts, the team of Lotto Zero. Lotto Zero is a creative hub, a textiles lab, a co-working space, is all under one roof in Prato in Italy. And we will meet there at the end of November, so very, very soon, to exchange ideas and knowledge on the topic of sustainable fashion, but also on how we can plan or implement the learning labs and to see with obstacles we all face during the process and how we can overcome them. So we really hope that some of you also will apply for the Learning Labs program. And if you have any questions about the learning process, about the application process or the Learning Labs, we really invite you to join us on the 16th of October. Maybe we can jump to the last slide of this deck. Yes, on the 16th of October, you can meet us from the Creative Flip team, but also our experts from Lotto Zero, Elena, who is with us today as well, to ask your questions, to learn more about what is important during the application process as well, and when we will select the lucky ones. And yeah, we hope to see some of you there as well. So let's start with the info session now.
Okay, thank you, Charlotte. Thank you, Dubravka. And good morning, everyone. Just a very short introduction. We are here today with my colleague Onur, both of us from the IP-Institut Luxembourg. Our organization is in fact the official counterpart of our intellectual property office, and we are mainly in charge of creating awareness about IP, developing and providing training in the field, develop and provide services to companies, and support our office in additional tasks related to international representation and activities. And our activities regularly led us to train players in the creative industry in our country, and we are pleased as such to have been partnering with the Flip colleague team since the beginning of the Flip adventure a few years ago. And we have already achieved some activities in the creative field in this framework, such as a report on patenting in the field, the development of an IP tool that you will find on our website, and train trainers in the framework of Learning Lab Action last year. After this brief introduction, and as my voice is a little weak today, as you may have already heard, I'm going to hand over to my colleague Onur. I will, however, still be there with you all in the background and possibly answer to some questions you may have. Maybe a side information, today's session will be recorded and made available on our website for your further consultation. I leave the floor now to Onur.
Thank you very much, Cyrille. Thank you very much, Dubravka, Charlotte. Nice to see you again. Like some of you, I already have seen the faces, some familiar faces, some unfamiliar faces, but I'm sure that you will enjoy this topic, and we will discuss about a bit about intellectual property. And let's move on to the presentation. But before maybe we start, we just need to clarify some points before we deep dive into the topic. First of all, this presentation is for you because normally as facilitators, you need to provide presentations to the students. And this is not the this is not the deck for the students. This presentation is just for you. And we will provide some material later on after finalization of the call, and we will do this in Prato. However, we will definitely also publish the presentation decks and the teaching material on our website. So whether you will win the call, you'll apply to the call or not, you will always get this training deck on our website. So don't worry. But this presentation is just to provide you a background about IP, because we know that some of you heard of IP, some of you are quite experienced about IP, but some of you, they don't know that much about IP. So it's a kind of a bit of a leverage, kind of find a balance within the audience and align the IP level of knowledge amongst the facilitators, amongst the audience right now. So we won't address you here as entrepreneurs because this is not a very advanced and full field, full coverage of the IP topics, but this is giving you the basics about IP as facilitators. Definitely this presentation will cover a bit of advanced topics for possible killer questions coming from your students during your workshops, during your IP workshops, but still, as I said, this is mainly a presentation in order to provide you some basics about intellectual property rights. However, if you have any questions, you are always free to ask your questions during the session or after the session. I know this is an online medium and it's not very easy to have this kind of an interactive mood, but we would like to make it as interactive as possible, meaning that please do not hesitate to interrupt me. Sometimes I can, because I'll be focusing on the presentation. So if I cannot, I don't see you that much, so please do not hesitate to interrupt me, and then just unmute your microphone and say, hi Onur, but we didn't get this point, or you can have, if you have any further questions, do please ask your questions during the course of my presentation, my speech. And the other thing that I need to underline is this is a bit more supranational, European supranational presentation. I know that you're all coming from different parts of Europe, and I know that you know that IP is quite harmonized in Europe. However, it doesn't mean that it is completely the same rules applying in all countries. So it is possible that your countries have different rules and different IP rights and different cases. So definitely we cannot address all countries' legislation here, but we'll be talking about more European level, supranational level of intellectual property rights. So if you have any specific questions about your countries, do please check your national legislation and national rules. This is very important. And we will definitely be here for you always. If you have any further questions, even after the presentation, you can always come back to us and ask your questions freely. And without further ado, we will start the presentation. And yeah, this is about Learning Labs call. And I guess you have all seen the Learning Labs call already published on our website. The objective, I mean, from the IP perspective, the objective of this Learning Labs call is to draw the attention and create awareness about IP in the context of creative works and the fashion industry, of the students, of the youngsters. Why do they need to consider intellectual property? So this is the main of the IP part of Learning Labs. And as the facilitator, you need to address these IP topics to your students. And what we expect from you is yeah, as you have already seen in the call, you need to provide at least 6 workshops on different topics to your students as the facilitators, and one of which will be about intellectual property rights. And as I said at the very beginning, we will provide you all the material about these workshops. Don't worry, but wait for it. It will be published in November, December, so don't worry about this. And what you need to do as a facilitator is to communicate IP to your students by using our material that will be published later on. You can provide your IP sessions as a standalone IP workshop, one of these 6 workshops, or if you wish, it totally depends on your program, it totally depends on your curricula that you are going to follow in your learning labs. You can also, apart from option to providing IP part as a standalone workshop, you can also distribute the topics, several topics, in different workshops as well. For example, if your students one day, if you are going to talk about branding or communication with clients, you can speak about trademark registration, which will be a part of this today's IP session in that workshop. One day, when you are talking about designing to your students, you can talk about design registration, which will also be a part of IP presentation of today. So you can definitely distribute different IP topics in your different workshops, or you can have a standalone IP workshop covering all IP topics that you need to cover to your students. So this is totally up to you, and this is totally how you create, how you design your teaching curricula. But what you need to do is you need to cover the IP topics that we are going to show you today, and that you are going to get relevant material later this year. And please do not forget to provide local examples, because it is easier to communicate those kind of local examples with youngsters. We will provide you some examples, a bit more general examples. We cannot provide local examples definitely here, but we will provide you some examples in fashion industry, so you can get inspired from those examples. So this is what you need to do in the learning labs from the aspect of IP, and definitely within your workshops, in order to attract more youngsters, it is totally up to you to, for example, find local interesting cases about intellectual property rights, or even inviting guests to inspire your students about use of IP in your area, in fashion, in sustainable fashion. So these are kind of a couple of tips for you when you are designing your application. Yes, IP is a very important element in learning labs, and actually it is a very important element in sustainable fashion in all cultural and creative industries. Why? Because it is the backbone of creativity. Actually, the name intellectual property actually tells you the importance of it. It is about an intellectual creation, and definitely all the creative industries, you are using your brains, you are using your creativity in order to create your work. And intellectual property is there to protect your work, and also in order to survive in the market and not to infringe the others. So this is very important. That's why IP is important in creative industries. It also rewards the creators, because if you have a protected IP right, first of all, you can make money out of it. It promotes innovation. It increases the value of your work, of your creative work. And it definitely increases the reputation, because once you say that I have a copyright on this work, I have a patent, I have a trademark on this work, it definitely increases the reputation of the creator. And it also has an inspirational effect. This is by nature. So I guess for until now, like everything is quite clear, because now I'll be deep diving into the different IP titles. Any questions until now, or should we skip to the IP titles? Then I'll be getting to the IP titles. But before we start and deep dive into the IP titles, this is something that I need to tell you. You can, I mean, like, this is something that you need to take into account, you need to consider, and you need to remember at first place. You are all creators. You all have your ideas in your intellectual worlds. But this is something we need to underline, that ideas that you're creating cannot be protected. They are not protected. I know this may create lots of questions in your mind. So if my idea cannot be created, so what I am going to protect, what I am going to, like, why do I need to use IP then? But I'll tell you what you are going to protect through IP. You cannot protect your ideas, but you will protect the product of your ideas. And then you will see what I mean. If you have ever followed an IP webinar or IP training, I guess this is something that you have seen, or something very similar you have seen. This slide, like, IP is everywhere. It is all around us. In a product, in a service, you can see different IP rights in just one product or a service. It can be a patent, it can be a trademark, copyright, design, or a trade secret. For example, in your phones, you have your Apple phone, you have your Samsung and Android phone. So definitely there are some patented specs of this mobile phone, from touchscreen to operating system. There are trademarks. When I'm mentioning your phone, I said Android, I said Apple, I said Samsung. These are all trademarks, or even the jingles, even the brands of your application, they are all trademarks. Design, the aesthetical, the visual characteristics of your phone. Copyright, like software, user manuals that we generally do not read, or trade secrets. They're all around us, and they are all IP. But from the sustainable fashion, from the fashion perspective, let's move on to another example. You know who this guy is? I guess it's from your actual domain. Any answers? That's a bit of an old photo, but this is Christian Dior. So and I'll have my examples around him. You'll see different patents, trademarks, designs, copyright, and trade secrets on him. For example, trademarks. Christian Dior is the creator of the brand Dior, and you have different trademarks that he created. Dior as a fashion brand, as a perfume brand. Christian Dior Couture is also another brand of him. Sauvage, a quite famous perfume, or J'adore, another perfume. So these are all brands. These are all trademarks. But he doesn't only have trademarks. He also has patents. I mean, Dior also has patents as well for cosmetic compositions, for bottle cap mechanisms, for technical textiles, because some textiles, they are resistant to rain, for example, or textile finishing techniques, or cosmetic display units, or even watches. So these are all technical inventions which can be protected as patents. Or designs, the shape of a bottle, the shape of an eyeglass, a sunglass, a shape of a bag, a shape of a shoe, a shape of a design of a dress, or a shape of a watch. But be careful, I'm always mentioning a shape of something, but we will come to this point about designs. Or copyright, like textile prints, patterns of Dior, which is quite famous. You right now see it on your left. The campaigns, advertisement campaigns, videos, photos, fashion show choreographies, music that is used in the fashion shows, or websites. These are all can be protected by copyright or trade secrets, like fragrance compositions, the exact compositions, the design methods, sketches, early sketches of some of the designs of the dresses, business and value chain management methods. So these can be protected as trade secrets. So you see, fashion is all covered by intellectual property rights. And now we start with patents. I know patents sound maybe very technical to you, and it is correct, and you are right that it sounds a bit technical. However, it doesn't mean that it is not used in creative industries, or it is not used in fashion industries. Today, actually, it is very relevant. I have quite a couple of examples at the end of this patents session, and then you will see how relevant it is. But it is sure that it is, I mean, not the most relevant, or let's say not the most used IP right, but it is still very relevant. A patent protects technical inventions, and it actually protects technical solutions to a technical problem. So it should be technical. And as all IP rights, it is protecting your work, your invention in that case, for a limited period of time in a limited geographic area. So this territoriality, that's what we call territoriality in a limited geographic area, is actually a common point of all IP rights. I'll come to this point when I'm explaining the other IP rights, don't worry. And yeah, as I said, patents, they protect inventions. So for an invention to be patented, it needs to meet these three criteria. First, it should be novel. It means that it shouldn't be disclosed. Your invention shouldn't be disclosed anywhere in the world before. It shouldn't be obvious. It should contain an inventive step, or other words, like it should be inventive. And it should have an industrial applicability. It means that it should be reproducible. I mean, it should be applied in at least one section of industry. I will not get into the detail, as I said, like this is not an IP training about patents. Otherwise, I would have talked maybe 6 hours about novelty and non-obviousness. However, this is what you need to know. It should be, an invention should be novel, and it shouldn't be obvious in order to be patented. Discoveries, scientific theories, mathematical methods, formats like TV shows, or game rules, or computer programs as such. I mean the source codes, or literary or artistic works like books. I don't know, like other artistic works like dancing, so on. They are not patentable because they are not technical inventions. You will see this last part in almost all IP titles. First, as I said, all IP titles, they are territorial. Second, as they are territorial, once you apply for it, it is actually, you have a granted right in this territory only. So you may have a question. So if I would like to have a patent in one country, okay, I'll apply to the patent office in that country. But what happens if I would like to have a patent, if I would like to claim my rights in other countries, patent rights in other countries? What do I need to do? Do I need to go each and every country's IP offices to file a patent? The answer is yes. Yes. Theoretically and practically, you can do this. You can go each and every IP office, each and every country, and apply for a patent right in that country in order to claim your patent right in those countries. However, I know it is not very, let's say, practical. So that is why we have different protection systems. One, yes, national application, meaning that you can go each and every country and then you file national applications in different countries. This is one option, but there's another option which is called regional systems, where you can file just one application, and in the end you can get protection in several countries through just one application. For example, a European patent, or a different side of a different leg of European patent is unitary patent, which is a patent for European Union in selected European Union countries, or a PCT application, which is not, which is generally, which is called an international application, not only valid for European countries or European Union countries, but for almost all countries around the world. So you can file just one application and you can get your patent granted in Europe, in the European Union, or in other countries of the world, just one application. So this is a simpler system so that you don't need to go each and every country. And the duration, as it is written at the very beginning there, it is like all IP rights are valid for a limited period of time. And for patents, it is for 20 years. And you cannot extend this protection. And this is quite logical because, as I said, like this is mainly for technical inventions, for technology. And you know that technology is advancing very quick, very fast, very rapidly. And generally, you wouldn't need, maybe medicines are a bit of extreme examples, but generally speaking, you won't need a patent valid for 20 years because the technology is advancing quite fast. So you need to have like patents provide you 20 years of protection with no extension. So after 20 years, it becomes public. However, in order to keep this patent valid for those protection years, for 20 years, you need to pay annual fees or maintenance fees or renewal fees every year in order to continue your protection every year within this maximum 20 years of protection period. I guess it is clear, right? So the question is, in the previous slide, I told you that it should be new. Like it shouldn't be, your invention shouldn't be disclosed anywhere in the world in order to get the patent. So how can you be sure about this? First of all, you can never be sure, 100% sure, because in the end, the examiner, you file the application and the examiner will decide by communicating with you whether you will get the patent or not. But you are not totally blind. Before you file an application, you can always use some public free databases to check whether your invention can be patentable in terms of novelty or not. This is giving you a kind of a rough idea about patentability. Definitely it doesn't give you 100% certainty about patentability, because as I said, it is in the end examined by the examiner. Second, you can never be sure about the full coverage or the update of those patent databases. However, this patent database that I'm showing you right now, it is ESPASnet. It is governed by the European Patent Office, and it is one of the most used patent databases, public databases in the world, because it contains more than 150 million patent documents. So you can check through this database if your invention has already been disclosed, or if an invention which is similar to yours has already been disclosed anywhere in the world. So this is a kind of a quick and dirty search which you can do. Another option would be you can always go and check with your national IP office or with IP professionals, I mean IP attorneys, patent attorneys or lawyers, to search for your invention before you file your application, so that you can have a bit of a rough idea about patentability, but you can also have your own search. You can also carry out your own search through this search tool. And as I said, patenting is not really something Chinese for fashion industry. It is quite commonly used for fashion industry. You see some examples here, and don't forget, patents are for technical inventions. So, for example, for Speedo, which is a fashion brand, a sports brand, for example, they have a patent about strap tensioner. Under Armour, they have a fast drying cloth patent. Burberry, they have a garment which has multi-layers. Louis Vuitton, Nike, Adidas, they all have different technical patents based on technicalities of their clothes, of their shoes, or the way that they use their techniques, clothing techniques, or hemming techniques. There's also, for example, a patent even for protection for animals having long ears, so that they are not disturbed by their long ears. Okay, this is for fun, but this is also a patent as well. I'm not 100% sure if it is really patentable right now in Europe, but at least it is patented in the United States. So you see, patents are also quite relevant in the fashion industry. Any news about patents? Because I will not get back to patents unless you have further questions about patents. Do you have any questions until now, or anything unclear? Then I will move on to trademarks. And I guess this is one of the most used IP rights, first all over the world, and also for you as well in the fashion industry, because this is the brand of your company, of your creation, of the item. So trademarks, they protect signs to identify you and differentiates you from the others, from the other brands. Because when you go to a shop and you would like to say, okay, I would like to have a Dior clothes, or when you say that, okay, I am now going to an Adidas store, you are giving the name of the store, Adidas. This is a trademark. Or you are giving the name of the dress, Dior. So this is how you differentiate your products and services. For example, in a store, this is a service, from the others. In order for a sign to be a trademark, it should be distinctive. Otherwise, you cannot differentiate yourself from the others. Or it should, it shouldn't be descriptive. Because remember, IP rights are actually giving you a monopoly of your work. So if it is descriptive, you cannot get a monopoly on a very descriptive, commonly used word for yourself. For example, if you are a producer and manufacturer of a shoe, you cannot brand your shoe as a shoe. Because like shoe cannot be a trademark, because shoe is the name of the item. Or you cannot trademark your clothes as the best, because the best it is just the adjective that you use it, and it is not distinctive, and it is descriptive. It is just saying that it is the best. So when you are selecting your trademarks, so a tip for you, maybe when you are having your sessions with your students, when you want them to pick a trademark, a brand for your creations, you may also, like touch on this point, saying, okay, be careful when you are selecting your trademark, when you are selecting your brand, it should be distinctive and it shouldn't be descriptive. So this is an idea of how you can touch on IP in your sessions.
Sorry.
So these are some examples about trademarks in the fashion world. For example, I mean, a trademark can consist of words like Zara. It can be just letters, H&M. It can be just logos, because as soon as you see the logo, you know that this is Lacoste. So it is distinctive. And definitely it is not descriptive, because it's just an alligator. Or it can be slogans. Just do it. When I say just do it, you remember which brand? I can't hear you.
Nike.
Yeah. Okay, great. So just to make you a bit of, also to wake you up a bit. Just do it is a slogan, is a registered trademark of Nike. Or even shapes. So a bit of a tough question here. Can you recognize this trademark? These soles?
Camper.
Yeah, exactly. Camper, exactly. So Camper has a registered trademark on this soles. This is a 3D trademark, and nobody in the shoe industry on shoes can use the same shapes at their soles apart from Camper, because it is a registered trademark, shape trademark, 3D trademark of Camper. And it can even be sounds, like jingles, for example, can be a registered trademark. Like, for example, I don't know, for example, Netflix Tada song is a sound trademark, and nobody in the film industry, in the video industry, can use this trademark, this sound trademark. For trademarks, it is important to mention that it is important for you to be the first in order to get a trademark. Because if it has been already taken by someone else before you, it might be possible that you cannot get your trademark. And when I was telling about my examples, you remember, I told you that, for example, for the Camper, I told you that nobody in the shoe industry on shoes can use the same shape on the back of the shoes. Or when I told you about the sound trademark of Netflix, I told you this tada sound is a trademark, and nobody in the video industry, in the film industry, can use this tada sound. Why did I mention it very specifically? It is because trademarks are registered according to the goods and services, which is called NIS classes. You don't need to remember this, but in literature it is called NIS classes because there's an agreement signed in Nice, the city of Nice, which is not nice. It is nice, but it is in Nice. Which means that you can file a trademark, a brand, a trademark, a sign for registration in different goods and services. The same trademark, but for different goods and services. This can be possible. For example, when I say Lotus, if you are around this Benelux area, as we are in Luxembourg right now, Lotus is quite well known, and I love it. It's a nice spread. Speculoos. This is a very well-known brand of speculoos, Lotus. However, and which means that it is a registered trademark for food, for this cream, spreadable creams. But we also have Lotus as a toilet paper. The same trademark owned by different owners, but it is a totally different good. Also, there is a Lotus branded watch. And even if you are really rich, possibly, and if you are quite curious about or quite like cars, you know the Lotus brand for cars, sports cars for brands. So you see, one brand can be taken by different owners in different goods and services. This can be possible. But you need to be sure whether the brand that you are going to get is used in your service, in your good that you are going to market your product or service in the market. In fashion industry, for example, you need to be sure if your trademark is being used by another person legitimately, I mean registered as a trademark before you. So you need to check it. I'll give you a database about this in the next slide. I told you, you will see this in almost all IP rights. Like in patents, trademarks are also territorial. But again, as I told you, you can file your application each and every country that you are interested in, that you would like to put your goods and services into the market. Or you have regional systems like EUTM, which is the European Union trademark. And it is actually valid for all EU countries. You can file just one application and you are registered, your trademark is registered in all European countries, European Union countries, sorry. And you also have an international registration system, which is called Madrid system, where you can file just one application and you can have your trademark registered for the countries selected all around the world. So these are two different systems, national application and regional systems, which you can go for it. And as I said previously, as in all IP rights, IP rights are territorial and IP rights are for limited period. And in that case, it is for 10 years. However, it can be renewable unlimitedly. So theoretically, IP rights are for limited period. It is registered for limited period because for trademarks, it is registered for 10 years. However, you can renew this registration every time for 10-year periods, like up to your will, unlimitedly. Yeah, Coca-Cola probably registered for more than 100 years. So you can have practically trademark registered unlimitedly. And this is the database that I told you. You can check whether a trademark has already been used, has already been registered before you in the territories, in the countries you are interested in, and in the goods and services you are interested in. Because, as I said, unless you are doing this in bad faith, you can have a trademark, one trademark in shoes and the other trademark in food industry. The same trademark in food industry. This can be possible. Or you can have a trademark registered in Germany and the same trademark, even for the same goods and services in Switzerland, if this trademark hasn't been registered in Switzerland there. So territoriality and for different goods and services. And you can check it on this database. This is again a public, free to use database. It's just a Google type search. You just type the trademark. You just enter, you can enter the goods and services you see there on which you are going to use this brand, this trademark, and the countries you selected, and then see if there's already an earlier registered trademark or earlier applied trademark there. And again, consume it, consume it responsibly. I mean, please always take into account that this will not give you 100% certainty whether your trademark is free for you to apply or not, because although there are more than 100 million trademarks there, you definitely, it doesn't give you 100% certainty that your trademark is freely available for you or not. But at least it gives you a very good idea. Okay, before questions, I'll give you some examples about trademarks in the fashion industry, like Cartier or Tiffany & Co. or Decathlon. These are all trademarks. Or what is this? This is just a logo, but
Chanel.
it is Chanel. So you see how it is differentiating its logo from the others. This is the main aim of trademarks. It is Chanel. And this one, a bit harder.
It's Versace.
Ah, yeah, okay, yeah, we have Italians here, definitely. It's Versace. And this one, a bit more difficult now.
Zalando.
Exactly, Zalando. We are great. And this, let's see. Now more difficult.
I don't know. Maybe Hermès.
Maybe what?
Hermès? I don't know.
No, but you're around, like it's Prada.
Ah, Prada.
Come on,
Yes.
there should be Italians, I know.
Yes.
Yeah, and this is Prada. So you see, even this is protected as a trademark. So like you see how it is differentiated, because when you see it, it is Prada. So any questions for trademarks? No? Right. Yes, please.
Sorry. In Italy, we have different brands that are very descriptive.
For
Like,
example?
for example, Scarpa, it's shoe, and there is it's very big brand.
Okay, so I then have two questions there. First of all, there are some national rules. I don't know the Italian rule, but I know, for example, in some European countries, there are some national rules. It is possible that some famous brands, they can acquire distinctivity because it is widely used and widely known. And in those cases, normally, when you file a trademark application, normally the office rejects this trademark because it is distinctive. Then, because it is not distinctive, sorry, or it is descriptive. But then you either oppose to this refusal decision or you go to the court to challenge this decision, and you need to provide that you acquire distinctiveness through use, through through invoices, through your financials and so on. So if you can convince the distinctivity through widely use of this trademark, then it could be possible that you can get this trademark registered because you acquired distinctivity. And we call it acquired distinctiveness in that case. The other option would be maybe they are using it without registration. Or the other option would be, okay, it is Scala, you said? No?
Scarpa.
Scarpa. But possibly they have a different font, different writing style, or a logo, together with Scarpa. So it is not only very like a common, boring way of saying Scarpa, but it is stylized, like way of writing, which is a type of a logo, and with maybe a design. So this is a trademark. not only Scarpa. Because, for example, when I say that in Italian, which I cannot speak, I go and buy Scarpa in Italian, would you understand, am I going to buy a shoe or am I going to buy a shoe with a brand of Scarpa? So this is a bit like, you know, like if it is very well known, yeah, you may think that, yeah, okay, this guy is going to buy Scarpa brand Scarpa, but maybe I'm going to buy just a Scarpa, but it can be Adidas. So acquired distinctiveness can be a possibility, or they are using it with a logo in order to make it distinctive from a normal Scarpa shoe word. Is that okay for you as a reply?
Mm-hmm.
Right.
Okay.
Do they have, by the way, do they have a logo or a different way of writing?
I think it's very basic.
Okay. I mean, like, I guess it's not like just Scarpa with, you know, like with the Arial characters, like it's not Scarpa. I'm sure that they have a bit of a different way of presenting their logo and trademark. But if it is a very well-known trademark, as you said, possibly they also acquire distinctiveness. But as I said, at the very beginning, I told you, that's why I told you that you need to follow the rules of your own national legislation. I don't know, in Italian legislation, you have this acquired distinctiveness, but in many countries, in European countries, there is this acquired distinctiveness possibility. If you can prove that you acquire distinctiveness through use, then you can get a trademark as well. Any further questions? Then, anyway, this is not the end of the presentation, so you can always ask questions and get back to trademarks whenever you want. And now we will be talking about designs, and then after the designs, I'll give you a bit of a break, maybe. I don't want to bore you, but for designs, this is also a very common IP right, IP title for designers, for fashion industry. We'll be talking about designs now. So you remember, patents are for technical inventions. Trademarks are for signs, brands, and designs are for design registration, is for designs, or let's say the appearance, the external appearance. You remember when I was giving you the examples, I was always talking about shapes of the product. So now we are not talking about the service, because like in trademarks, you can also have a brand for a service. But here, as we are talking about a product, an external appearance of something, it should be a product. However, we are not protecting the product itself. Otherwise, it could be a patent. We are protecting the external appearance only. It can be 2D, 3D. For example, it can be an ornamental element of a necklace, of a jewelry, or patterns can be protected, the patterns. And it should be the aesthetic character of your product, the appearance of the product. And as we said, it shouldn't protect the product itself. This is a very nice product, maybe, where you don't need to like fill in your beer every time, so that you have a hat with a huge like a container, and you can have your beer there. But you cannot protect this functionality. You cannot protect the idea of having this beer on your head with this barrel, with this container. But you can protect maybe the external appearance, but there's nothing to protect this external appearance, because this is not original at all, because this is just a very common container. So what you need to know, what you need to keep in mind about designs is they protect the external appearance, but not the product itself, not the functionality, because functions are protected by patents if they are technical. So, for designs, you remember when I told you that having this container on the top of your head, it cannot be protected, definitely, because it can be protected, maybe a patent. As a design, you can protect the overall design. However, it cannot be protected because it's not new. And I said this for a purpose, because in order for a design to be protected, it must be new. And it is very important. I'll underline this again, but this is something you must take into account. You must always consider it must be new and it must be original, or it must have an original individual character. It must reflect the character of its designer. So this is important. And this novelty means that it shouldn't be disclosed, the external appearance shouldn't be disclosed before your filing. However, in Europe, there is a grace period, this is what we call grace period, for 1 year, which means that after your disclosure, you have 1 year to file your design application. But if you don't file your design application within this 1 year, if you just exceed it for 1 day or 1 hour, you cannot get the design application. Your previous disclosure, which you made more than 1 year, can be a barrier of your design application, design registration. So that is why we always tell designers that don't disclose your designs, first file your application, then disclose it. This grace period is always, open the discussion. I mean, you always need to prove it. So in order to not to, prove that it is within this 1 year. So in order not to, be challenged about this, it is always to be on the safe side to file your registration before your disclosure. But if you disclose it, you still have at least 1 year grace period. So now you remember those 3 items. Design applications, like in patents, trademarks, they are territorial. You can go each and every country. However, we have, again, regional systems, very similar to the trademark. We have a community design, which is actually a European Union design, so that you can file one application and you get your design rights for all 27 countries, 27 EU member states. Or we have an international system, which is called the Hague system, where you can file one application and you can get design registration for the selected countries that you selected during your application, so that you don't need to go each and every country at the very beginning. And yes, it is territorial. And remember the second thing, it gives you a monopoly for a limited time period. And the time period for patents, 20 years. The time period for trademarks, 10 years, extendable. And for the time period for designs, it is 5 years. But it is not the end of the world after 5 years. You still have 4 times, each time for 5-year extension, so that you can complete the whole registration period to 25 years maximum. After 25 years, it becomes public. So you cannot extend it unlimitedly, in contrary to trademarks. In the EU, this is very important because it is just valid in the EU countries, not in other European countries, nor in other international legislations, unless they have a very specific rule. There is a system called unregistered design, which gives you only 3 years of protection after your disclosure. And this is just valid in the EU. which means that if you have a design and if you have disclosed it, you disclosed it, and it is automatically, it's like copyright. I'll come to copyright later on after the break. But if you disclose your design, you have an automatic protection of 3 years in Europe of this design. So if someone steals your design after your disclosure, you can always sue that guy basing on the fact that you have disclosed it. And it is an automatic, there's an automatic protection for 3 years starting from your disclosure. However, there is one thing to remember. This is against bad faith. So you need to prove that this guy, for example, this is just an example, you disclose your design, for example, in a fashion show, and you know that that guy, a guy, came to this fashion show and saw your design is not registered, saw your design and then copied that design and then now on the market. Then you can claim that, hey, no, I haven't registered my design, but I disclosed it and that guy was there, so he copied my design. Bad faith. You need to prove that that guy was there and he copied it deliberately, and then you can definitely file a lawsuit against infringement of your unregistered design. But it is also possible that you can file a design registration. However, again, you have 1 year after disclosure. Anything unclear?
No, I was wondering how often it happens nowadays to register designs, because since everything is always shared and reused, there is, I mean, not really an invention, I feel, in the fashion design realm.
I'll ask
I
this
don't know.
question.
I
Do
mean,
you
there
think?
are some things that are very iconical, like, for example, I think to Bottega Veneta, oh my God, intreccio, the weaving part, the woven part, sorry. But then in terms of really like the design that you see on the catwalks, I think it would be very hard to decide what it's really unique and original. I don't know.
Well, okay. Being unique and original and new is a different discussion. It is about registrability. It is something different. But I'll ask then this question. For example, you saw a fashion show on, like in Italy, you went to a fashion show and you saw a design there. Would you copy it and then use it on your products? Would you take this risk? I mean, this is a huge risk. First of all, if you see this on a fashion show, it means it is disclosed and it is protected. First of all, it is protected there because as soon as it is disclosed, it is protected because it is unregistered design for 3 years. Secondly, you will never know if this guy has already filed a design registration on this. And maybe he has a design registration. So how you cannot take this risk to copy it on your products. Concerning if it is common, it is very common. You are a designer. Would you like your designs to be copied? Would you take this risk? And would you be happy if you see this design on another product? Definitely, as I said, like being new and having an individual character, these are two different things. But if you designed it on your own, it means that it has an original character. It reflects your personality, unless you are deliberately copying it from somewhere else, definitely. But novelty is also, definitely it is questionable, but if you make it on your own, let's think that it is new and it is original. Why wouldn't you register it for yourself and then block the others to use it? Because IP rights, they are used for blocking the others normally, protecting yourself. But how are you protecting yourself? You are protecting yourself by blocking the others. This is the negative aspect of IP rights, especially for patents. This is the case. And
No,
yeah.
No, I was just thinking and I was just wondering if it's so easy nowadays to be really unique in terms of style. Because like if you look at the last collections, for example, that were presented a few days ago, they are not so different one to the other one. There are many things that are really similar, and they were presented all at the same time. So I don't think it's a matter of copying each other. It's just a matter of probably like influencing each other, because I mean, really in this era, in the contemporary era, I think that it's really complicated when you talk about style to talk about being original, because we share so many things. We are in a globalized world. So, and I mean, it's not when something is technical, I think that is very easy to determine this was invented. I mean, I can imagine it's quite easy to determine this was invented by me and it's something unique. But in terms of style, I think this is very, very, very complicated, honestly. I mean, I think there are just a few things that
in fact,
it can't be questionable.
It is related to similarity. It should be exactly the same. If it's not exactly the same, then it's different. You see?
Normally we are talking about overall impression in those kind of similarities, and when you are detecting if there's a similarity or not, overall impression on an average consumer. You'll see some examples in my next slide, but yeah, you are right that especially in this era, it is not very easy to yeah, you always get inspired, but this is something else. I'm sure that you can, I mean, like, okay, I'm not a designer, and I wish I could, but I cannot. I'm a very like a unskilled person in those terms. But I'm sure a designer can, when he sees two different ornaments, or when he or she sees two different designs, I'm sure he or she can differentiate those two designs. And as long as you differentiate those two designs, it means that these are two different designs. But if someone is copying, if one design resembles the other design, then this is always a question: to what extent they got inspired, to what extent it is similar or not. This is, this should be decided by the courts or by the IP offices. This is not the aim of this this session as well. But you are right. It is not very easy to be very original, but come on, you are designers. I am sure that your creativity is limitless. You can definitely find new designs and original designs, and you'll see some examples. Cyrille?
There is also the option for you to check if your design the design that you have developed has already been protected or not, using design databases. So you can enter a picture, let's say, of the design into the system that will look for a similar design, and then you will be able to judge if you are infringing others' rights or not. Another element is that in order to enforce their rights, the IP owners have to take some actions. It is not the system, it is not the government that will take the action, that will look for similar designs, for example. It's to the developer of the designs to ensure that the similar design has not been developed on or registered to enforce his rights.
But it is true that it is like in when Cyrille said like a way you can check databases, which I'm going to show you one example again. It is definitely not a very clear cut like in trademarks or patents. Maybe in patents and trademarks, you can easily say whether two inventions or two trademarks are similar or not. A bit more easier than designs, but in designs, it is not that clear cut, not that straightforward. So it is true. It is more subjective in designs, especially when you are determining whether these two designs are similar or not. But we are talking about law. Law by nature is subjective. It's not science. So that is why, yeah, you always have this reservation about similarity. What we need to be sure is you need to protect yourself against copying as a designer, and you need to be sure that you are not stepping on the other's feet by infringing them. And for this, yeah, you need to be sure you are not very similar to them. And this very is very subjective, but it's by nature. Yeah, I know it is not the most clear-cut answer, but this is again like a similarity.
No,
And,
I was also wondering if this is something that still happens a lot with young brands, or also not young. I mean, just brands.
But I know that like many fashion houses, they always register their designs, always. I have some examples. Let's see. Okay, before coming to these examples, this is the database that you can check if you have any similar designs like around Europe. Again, consume responsibly. Again, it doesn't give you, it just gives you a very rough idea about it. And also it is again very subjective. And to be honest, it is not very used because of its high subjectivity when it is compared with trademarks and designs. But still, if you wish, you can always either type the indication of the product or upload the photo of the design, and then the database checks whether there are any similar designs. But again, similarity is up to you.
Maybe an additional element for you. In the textile industry, the unregistered design is widely used, especially for the pattern of the tissue that is of the fabrics that is used for the clothes. Because as you know, in the fashion industry, the different collections are just last a few months. So for that reason, you do not necessarily need a registration during years. So this is the reason why this unregistered design exists. But of course, on the other hand, it does not provide the same level of protection as a registered design. It is, let's say, weaker.
Yeah, and as I said, it is against bad faith. So you need to prove it. So this is, you need to be careful about this unregistered design. I'm not telling you that you need to register everything, but at least you need to know the differences. So for example, these are some registered design examples. For example, this is a registered design of a cloth. These are like patterns that you can never use. I guess you know all these patterns, Burberry, Louis Vuitton, Versace. And, this bar, chair, stool, or I guess it's a bracelet or a necklace, shoe, these 3 stripes, or even this lamp. Not the technicality, not how it is opened or closed, but the different visual characteristics. When it is closed, it looks like this. When it is half open, it looks like this. And when it is open, it looks like this. So these are all different. So which means that nobody can use the same aesthetical appearance of this lamp on their lamps.
But
About the
sorry,
design.
I have a question.
Sorry, yeah, Elena, please.
Sorry, on the previous slide.
No.
But yes, my question is, but these three patterns, are they considered as trademarks or as designs?
This is a great question, and this is called accumulation of rights. Both.
Okay. Okay.
You can have both for one product or for one item. You can have both trademark or copyright or design. It is possible. It is called accumulation of rights, but they have different meanings. Remember, trademark is differentiating. It is for differentiating your sign from the others. Designs are protecting the outward appearance. So the sense is different. However, yes, you can accumulate IP rights in different IP titles in one product. This can be possible. And in that case, yes, they are both trademarks. So nobody can use this pattern as a trademark apart from Burberry or Louis Vuitton or Versace. And nobody can use this pattern on their designs. Clear?
Yeah, okay, thank you.
Right. About the disclosure, this is very important that I would like to, that I told you that I'll get back to this point again. And this is also one of the examples that you need to show your students. Because I told you, design disclosure is very important. Your designs must be new. And if you file your design registration, after 1 year grace period, your own disclosure may block your design registration. And here's a funny but true story, which happened quite recently, this year actually. This is a Puma shoe, and it is registered as a community design. Elena, you see? Still they are registering their design. So Puma is has registered this design, and it is a registered design filed for registration in July 2016. But 20 months before this design, 20 months before, Rihanna on her Instagram, on her personal Instagram, she was sharing news about appointment of her new creative director, totally irrelevant to the shoes or design or IP. She was just saying that I signed a new agreement with my new creative director. Say hi to my new director. And then she shared a photo. And in that photo, she was wearing a Puma shoe. And she shared this in 2014. And this Puma shoe is the exact shoe of which Puma filed registration in 2016. They have 20 months in between these two, one, the disclosure, the Rihanna's post, and the registration application. And definitely there was someone who opposed to the registration of Puma, saying that no, you cannot file registration because it is not new, because it was disclosed almost 2 years ago by Rihanna. And the court decided. Here's the decision of the court. The community design was annulled, was cancelled. So you see, design disclosure is important. You need to be very sure about it. So you see, this is a very new decision in this year. So this 12 months you need to respect. Okay, so now we will be talking about trade secrets. Trade secrets are a bit different from the other IP because trade secret, okay, this is the maybe very small, let's say, detail for you, but this is what I need to say. Trade secrets are not IP rights because they do not provide you exclusive rights. I'll tell you about it. So trade secrets are they are for protecting confidential information. And this is, as I said, a bit different from the other rights because remember, when I told you about IP rights, I told you that they are territorial and they are limited on time in terms of protection. But for trade secrets, it is not within this circle because it is not an IP right. And it provides you protection for an unlimited period as long as you keep it as a secret. So once you reveal the secret, once you reveal the confidential information, it is not a trade secret anymore. So as it is a secret, there is no registration. You cannot register anything because registration means also revealing it. So you are not revealing it because it is a secret. And it is not an IP right, but it is called an IP asset, or it is within the framework of intellectual property, but not as a right, because it doesn't provide the owner an exclusive right to block the others. It has a different manner of enforceability. You can enforce definitely your trade secret against the others. However, it is not for creating a monopoly, because for the other IP rights, you are creating a monopoly. You have a trademark, you have a copyright, you have a patent, you have a design, and you are creating monopoly for a limited period of time in the limited geographical area, saying that you cannot do this because I have this right. And then you can sue the others if they infringe your right. But in that case, it is not the case because it is a secret. So you cannot infringe the others you cannot enforce it through this claim. You can enforce it through misappropriation, but not to create a monopoly, unlike the other IP rights. That is why it is not seen as an IP right, but it's an IP asset. But the advantage is it doesn't have, you don't need to have a register, you don't need to register anything, and it is for an unlimited period, question mark, because unlimited means as long as you keep it as a secret. So what could be a trade secret? It can be in your area. I'll come to the examples later on, but how to keep it as a secret? Through technological measures, by document marking, or employee training through non-disclosure agreements. These are the ways of keeping a confidential information as a secret. So what are the examples? A very well-known example, Coca-Cola. Another very well-known example, KFC. For example, for KFC, the recipe is protected in a room with unique PIN codes. Just 2 executives know it, and they can just merge their information, these PIN codes, and they can enter this room to get the recipe. And half of the spices are mixed in one factory. The other half is mixed in the other factory. So each factory, they don't know what the other half is. So you see, they are keeping this as a secret. in fashion industry, for example, the notes of a perfume, or let's say the ingredients of a perfume is a trade secret. You know, like when you see the ingredients of a perfume, you will never see the percentages of each aroma. But you will just see that it has these notes, it has these notes, it has these accords, it may contain this and that, sandalwood, and I don't know, like bourbon vanilla, but you will never know the exact percentages. Or the other one, the trend forecasting. What will be fashionable in the next season? So it is studied in closed groups by the fashion houses, and then they will decide it beforehand, and they are keeping it as a trade secret, and then they will then reveal it later on. So these are the trade secrets. Not much to say about trade secrets. We have in Europe, we have a directive, and yeah, I guess, and this is not really the aim of our learning labs, by the way. We are more dealing with IP rights here. And then the other very commonly used IP right for creative industries and sustainable fashion industries, it is copyright. We say copyright, but actually it is called others' rights of the others and the neighboring rights. This is the the long name of it, but it is well known as copyright. So copyright is relating to literary and artistic creations. So it can be any field of cultural industries. It can protect novels, like in literature and press, or news articles. It can be music, lyrics, compositions, audiovisual art or audiovisual work, cinematographic works, stand layouts, booths, exhibitions, like in cultural heritage sector or festival and fairs sector, architectural works, maps, plans, designs, video games, gaming characters, or in fashion, the designs, the ornaments, the handcrafts, paintings, sculptures, or when you are in a fashion show, the choreography, the music coming with the choreography, photography. So these are all can be protected as a copyright. So these copyright relates to literary and artistic creations. But again, you remember the big exclamation mark I told you at the very beginning? It is not protecting the ideas. Copyright doesn't protect the idea of there will be a young wizard going to the school. He will be with his friends and there will be adventures around it. This is not protected by a copyright. This idea can be used by other authors. However, what is protected is how it is storylined on a book. Harry Potter. So the same idea can be storylined in other books. I mean, Harry Potter is not the only book who has the young wizard. There are many books. So that is why ideas cannot be protected. Copyright protects the physical expression, how it is expressed on something. That something can be a book, can be a music, can be a choreography, a dance performance, a sculpture, a bridge. Copyrights, they in Europe mainly, generally, there is no formal mandatory registration for copyright, and it is automatic upon the creation of the work. So once you created it, automatically it is protected as a copyright as long as it is original. Again, it reflects the personality of you. As long as it's original, you can say that I have a copyright on this because I created it. In some countries, normally copyright is owned by the original creator, the author of the work. But in some countries, especially depending on the work contracts, it could be possible that the employer can own the copyright. So that is why it is always, you need to be sure about your own country's legislation, or at least when you are signing a contract. For example, if you are a subcontractor of a design, I mean, you need to design something on behalf of someone, you are a subcontractee, then in that case, you need to check your contract, who owns the copyright. Are you the owner of the copyright, the final work, or are you transferring your rights to the subcontractor? So this is important. And copyright is also territorial. However, you may ask, okay, Onur, like for patents, trademarks, designs, we understand territoriality because you register, and then you need to register each and every country, so there's territoriality. But copyright, there is no registration. So what is territoriality there? The territoriality in copyright has a different meaning. It means that each country, they have their own national rules and they decide how to manage copyright in their own countries. For example, in terms of exceptions, because maybe you have heard of it, in some countries, there's an exception of education, meaning that there can be a copyrighted material, but as long as you use it for non-commercial educational purposes, you are just going to show it to your students as an example in your school. Then the copyright owner cannot claim his copyright and block you not to show it. This is called exception for education, but it is possible that in some countries there is no exception such. So that is why you need to check your own national rules. So this is territoriality in copyright. But like in all IP rights, there's territoriality in a different meaning, but also there is this limited protection period, which is the case for also copyright, definitely as an IP right. And this is 70 years after the death of the creator. I mean, it starts with the creation of the work, and it lasts until the end of the creator plus the death of the creator plus 70 years. In case it is made with a group of creators, it lasts after the death of the last author plus 70 years. So this is the main rule. Actually, it is minimum. It is mainly 50 years, but in Europe, in general, it is 70 years after the death of the creator. So your copyright is protected until you die plus 70 years. And there is no extension. If you have a copyright, it means that you can decide how to make use of your work, how to disseminate, how to communicate, how to modify, how to adapt. It is totally up to you as the creator of the work. And you can prevent the others to use it. Definitely, you can say that, hey, you cannot use my copyright, you cannot alter it, you cannot modify it, you cannot adopt it. For example, you are the owner of the book of Harry Potter. If there's a movie on Harry Potter, you can say that, sorry, but I have a copyright of this book. You cannot base your movie on my book because it is a copyrighted material, and you cannot modify it, you cannot adopt it to another medium without asking my permission. And you can definitely, in return for it, you can ask for remuneration. This is the main aim of IP rights by way of protection. That is why you protect your work. have a reputation. At the very beginning, I told you reputation, and also to have money. In copyright, we have two types of rights. One is called economic rights. It's about like a reproduction of your work. As an owner, you have the right to reproduce your work, and you have the right to choose who can reproduce your work through licensing. Adaptation of work, I told you, like Harry Potter. But translation is also an adaptation. So nobody can translate your work into another language without asking your permission. You need to, she needs to take license from you in order to translate your work. Or communication and distribution. These are all economic rights, but there are also moral rights, which are about the characteristic of the owner, of the other. I mean, paternity and attribution, integrity of the work, like the work is integrated, it cannot be like departed, and the right to disclosure. Maybe you also have heard neighboring rights. These are mainly the rights of the performers, producers, broadcasters. For example, you have composed the music, and someone is dancing with the music. Definitely, the music composer, you need to get the right from the music composer, but you are also performing it or dancing it. But while you are performing it, with the performance in an orchestra, for example, of this music, you have your own right about performing of this music. So this is a neighboring right, neighbor to the composer of the music. These neighboring rights, the duration of those rights can vary from country to country. In some countries, 70 years, in some countries, 50 years. You need to check your legislation again. Especially in the music industry. The music industry is quite relevant to yours, especially in your, for example, your show cases, your fashion shows, because you are using music. Don't forget that you need to take permission from the owner of this music composer, first of all. And second, you need to have, if you have a choreography over this music, you have this neighboring right, definitely. In the music industry, the copyright owners and neighboring rights owners, their rights can be managed by collective management organizations, CMOs, so that they can collect your royalties. And then they can, like share these royalties with you on behalf of, because it's not very easy to, to check who is using my music, if it is on YouTube, and when you are granting different licenses, you need to collect different license fees from many others. So it can be very hard to manage, especially for music owners. So collective management organizations, they are doing this on behalf of you. It is not maybe you who will be a member of collective music CMO, because you are not a music industry. However, you may need to contact with a CMO if you would like to use a music on your fashion shows. So that is why it is important. That's why I just put it there. Being a creator means you created this piece of work, music, book, fashion design, choreography, whatever. And you have the copyright. However, proving the ownership is different. And you can, it is not very easy for sure, but there are some options to prove that you are the owner if there is a need, definitely. For example, you can go to a notary. You can send, for example, if you created something, a design, and if you designed it on your own, you can send your early sketches to yourself via a registered postal letter, so that you have the stamp of the postal office on the date. So you know that it's on that date, you send it to yourself. or there are some virtual, more technological proving systems like eDepot, which is governed by Benelux IP office. So it is an online virtual sealing. What you need to do is you just upload your creation online, and then you receive a virtual seal saying that, okay, this guy, this creator has filed that work on that date by himself, herself. Definitely, it doesn't prove the certainty of the authorship of the content. I mean, you can just put someone else's work there. However, it might prove, I say might, because it depends again on the national legislation, whether your national legislation would accept BOIP or notary deposit or postal letters as a proof of ownership. It totally depends on your national legislation. However, it may prove that this work was possessed at that specific time by you. So this proves that. But other than this, definitely proving the ownership, proving that you did this is not, I mean, nobody can 100% be sure about this. And it is a question of law, national law. So to validity of those tools, you need to check your country practices. For those, generally, you need to either go to your IP office, or your Ministry of Culture or Education, or an IT professional in your country. That is all for the IP part. I don't know if you have any questions about copyright, because while I'm checking the registrations, I saw there some questions about some particularities, which I would like to address here now. So if you wish, let me finish this part, and then I'll take the questions and answers later on, because maybe you are going to ask the question that you have already written down in the registration form, so that maybe I'm already addressing it right now. And then let's go with this. It is about copyright and copyleft. I saw this photo, sorry, I saw this question in the registration form that, okay, copyright is for others' rights. So how about copyleft? Can we copyleft our work? So I just would like to underline the notion of copyright and copyleft here to make everything clear for you. Copyright, the famous C in this circle. It restricts unauthorized use, because I told you, you are the owner, you are managing your work, how to distribute, how to adapt, how to, like translate, whatever, disseminate and modify. When you have the copyright, you have the restriction to use, you have the right to restrict the others to use your work. And you can claim the authorship of the work, and you are the one who is going to make decisions about it, as you have the copyright. And it is a way of making money and recognition, definitely. So the best practice is how you claim your copyright. There is no registration, I told you, in Europe in general, at least not obligatory registration, let's say. So the best practice would be, it is always good to put this cute C together with your name, the other's name, plus the date, so that people would know that this work is copyrighted by that person or that team, starting from, disclosed from, or whatever, that, or created from that date. You can also add a disclaimer and a copyright notice. Actually, we will have an example, a sample of copyright notice and copyright disclaimer on our website, which we are going to share with you quite in upcoming weeks. But the best practice would be putting this copyright sign on your works, so that everybody at least would know. This is not mandatory, by the way. This is not mandatory. This is not legally mandatory. However, it is always good to, like at least inform the others that it is a copyrighted material so that they will be careful when they are using it, or at least who to contact if they would like to use it. For example, this presentation is under the copyright of Creative Flip. And copyleft. So is it the opposite of copyright? The answer is no, not at all. Actually, copyleft, in order to have a copyleft, you need to have a copyright. They are going hand in hand. Because in order to say that you have a copyleft, you are providing this work without any restrictions. You need to be the owner, first of all. So you need to have the copyright of it. So copyleft means you are granting unrestricted use, dissemination, modification, granted by you, because you are the copyrighted guy, you are the owner. However, with the copyleft, you ensure that the derivatives of the use of this copyleft is also preserved for other subsequent users. Actually, I'll give you an example. Actually, copyleft, the term copyleft is mainly used in software industry. So when you say copyleft, actually you are talking about normally software. However, it can be used as a broader meaning, covering all other industries, like in design, copyleft of a book, copyleft of a design, of a music. However, you need to mention it. And in software, as an example about what I wanted to say at the beginning, like unrestricted use, and you need to give the same freedoms to the others, to the derivatives. You have a software, you say that I am granting unrestricted use. Everybody can use this source codes, this software. You can change, alter the software. However, the altered product by you should also be free, should also be under the same conditions. This is copyleft. Creative Commons, you have heard of it, I guess. It is, in a sense, it is not exactly the same, not at all, but in a sense, it has a similar spirit, not same, but a similar spirit. There, the owner of the copyright, again, copyright, you need to have a copyright first, decides which rights to grant the others. For example, CC BY, saying that you need to attribute, you need to mention the owner of the copyright when you are disseminating, when you are using my work. CCSA, CC share alike, you need to share under the same conditions of me while you are using my work. CCNC, non-commercial, you need to use this in non-commercial medium. Or CCND, CC non-derivatives, no derivatives. There is no derivative. You cannot produce anything, any derivatives by this work because it's copyrighted and I don't let you do any derivative work. So for more information about Creative Commons, there's a link there. You can just go there and then you can have the meanings of what they are and how you can grant licenses. But copyleft, it is mainly for software industry. However, you can use it in your own works as well. However, it means that you are making your work free and the same freedoms are preserved for the other subsequent users. The other question is about AI. And this is actually the slide of buts. You will see lots of buts in that slide because AI is not very well and 100% regulated. We have an AI Act in place. However, it is very new, starting from the August, just a couple of months ago, even weeks ago. And we really need to see how it is implemented. And there are still some parts where we are still waiting for the implementation rules. So that is why there are lots of buts. And because of the nature of AI, it is growing rapidly. And sometimes, law is not really catching it that fast. So that is why this is a slide of buts. You'll see what I mean. So about AI and IP, how they can go hand in hand. And I'll just make it like in 3 questions to simplify it. Because in AI, you have 3 main issues. The first issue about AI, the first question that may come into your mind, you're all using, I don't know, ChatGPT, Claude, or Bing, to Google. If AI created something, can he be the creator, an AI? The answer, I'll get to the answer later on. The second question about AI. If a work is generated by AI, how it can be copyright protected? The first question, can he be the owner, the copyright protected? And then if it is protected by an AI, maybe with the prompt of myself, can I still claim copyright on this? Because it's not really created by me, but with AI. So this is the second question. And the third question, if there is an AI generated work, can I use it? Is there a risk of infringement of can AI claim its copyright? Then moving back to the first question, can AI claim its copyright? And actually this is the answer of the first question. AI's ownership on AI generated works. The answer is no. It is because AI cannot claim its copyright because it has no personality. It doesn't have any individual character. You remember when I told you about copyright, I told you that it should reflect the individual character. So by law, individual character comes from its human specs. As AI is not human, it doesn't have any personality, and it doesn't claim its rights against you. Because it's not a human, it doesn't go to the court and say that you are infringing my rights. So it doesn't have any legal capacity, it cannot use its legal rights. That is why AI cannot be an owner of an IP. But it is, at least for now, because if one day, I guess you watched Black Mirror, if one day, if it gains personality, if it has the capacity of taking legal actions, yes, why not? But this is at least not the question of today. Today, we are safe, and as it doesn't have any legal capacity and it doesn't have any personality for now, no, AI cannot be an owner of an IP right. Then, if a work is created entirely by AI, can it be protected as a copyright? The answer is no, because I told you there is no owner there, because by legally there is no owner. So no, if something is created by AI entirely, it is not protected by a copyright. But this is a very theoretical question because we don't have any higher court decision yet on this. So I cannot tell you that. That's why it is mentioned in principle at the beginning. I cannot say by law it is not protected. I cannot say it, but in principle it cannot be protected because it doesn't have any personality. And there is no owner of this copyright, this work, because AI cannot be the owner. But then the question, if this work is modified or generated by a human interaction, then a copyright can be possible for that modified parts or for that human interacted parts for the human part. What I mean is, for example, it might be, again, I am saying it because there is no, I cannot say that it is by law. There is, again, no higher court decision about even like this partially modified AI generated work right now. So I don't know, nobody would know if there is no European higher court decision. I'm talking about Europe, by the way. For example, if you created something with a prompt, for now, the work, AI generated work, the overall production, there is no copyright. However, you can claim your right on the prompt, but I don't know why you would need to do this, because one prompt may create thousands of different generations. So, I mean, like works. So maybe protecting a prompt as a copyright is also not very logical, at least, but at least in principle, it is possible to claim a copyright if you modified an AI generated work, but just for the modified part, or but just for the interacted part, unless it meets copyright requirements, or I don't know, like the requirements of other IP titles. And then maybe the most asked question from you, it's about the use of AI generated works. If there's an AI generated work, can I use it? Is there any infringement risk? The answer, actually no, because I told you that if there is no ownership, if there is no copyright, then you can use it. So there's no infringement risk. But, I told you, this is a slide of buts. You know, AI, they are working on the principle of trained data, already available data. So you feed AI with the state-of-the-art data, which can consist of IP protected material. So the AI may use the IP protected material in its training data and then generating something by this trained data, and then the generation may resemble, may be similar to this trained data, which can be protected by an IP right. So there is actually an infringement risk in that case. Then the question is, how can you be sure about the training data? Like, can you see the training data? Like, can you be sure how, like, do you know how ChatGPT, the training data of ChatGPT, like, do you know that whether it takes IP protected data as a training data or not? No, we don't know. So you see, there is always a risk. We don't know. There is an AI Act, I told you, which is very recent. And it provides for it asks AI providers to be transparent and show the training data. They need to be transparent about their training data. So you can be, at least now in Europe, after this AI Act taking into place in full, you can see the training data, but how can you be sure whether they are providing the full data? How can you be sure? Like, you know, like it is the provider of the AI who will say that, okay, I am training my data, my AI with this data, but maybe they are not providing the full list. And maybe like they are taking the AI protected material, which they haven't disclosed. And if you use this generated work on your work, maybe you are infringing this IP owner. You cannot control it, at least for now. Yeah. So what can you do? What you need to do is, if you are using an AI work, if you are saying that, okay, ChatGPT, I would like to create, I don't know, like a cloth, a summer cloth. Short sleeves, it has, you know, flowers on it, daisies. It's colored this and that. I don't know, like it has this nice skirt, but I don't know the terminology in fashion, by the way. So you can have a prompt, and then in the end, you have a final design. You may say that, yeah, it is AI generated. There might not be copyright, but yeah, again, I said but you don't know what training data he used. So what you can do is you can check the terms and conditions of this AI and check what can be used by this training data, what can be used by through this AI, the use of AI. Can you use this AI protection? Can you you use this AI product? If yes, in which conditions? In what conditions? Maybe you need to mention that it is generated by ChatGPT. I don't know. Or maybe you can't. Or maybe, for example, in FreePick, that you see some of the pictures in these presentations, they are from FreePick. And some of them are created by AI. I wrote the prompts and then it created it. And then we have the premium user. So we paid the fee to use the AI. And in the terms of conditions, it says that, yes, for the AI, you can use it. And that you mention it that it is generated by AI and blah, blah. This is what I did. You need to check it. But not all providers are using that clear terms of conditions. So this is also not very clear. Maybe in order to be on the safe side, you can add this work is generated by AI, but you can never be sure if it is saving you from potential infringement accusations because you don't know the training data. So you see, these are the slide of buts. There are lots of buts. We don't know what will happen in the future, but you need to be at least careful when you are using the AI generated works. So if you have any questions, I'm ready to get together with Cyrille, together with Charlotte and Dubravka. But for the winners of the call, meet us in Prato in November. Just encourage you to apply for this call and then win the call. And then we will meet face to face in Prato. And then we will speak more about IP and speak more about how to communicate IP with the students. And we are going to give you the material, the training material that you are going to use in your workshops. But don't worry, we will also publish it on our website, and then you can make use of it. Copy left. You can make use of it freely in your works by attributing to us CC BY and. Yep. So this is, we wish you best luck in the call applications and looking forward to working with you. And let me know if you have any questions for today's session. Then I will say goodbye from our side, and then I'll give the floor to Dubravka and Charlotte. We will put this presentation on our website, and you will see all the links and the presentation on our website. And then you can always stay in touch if you have any further questions. And I'm now closing the recording, Dubravka, if okay for you, and then you can close the session.
Thank you very much, Onur.